I guess I need to know how much louder we need to.
Do we need
to talk louder, Jay?
I think that ought to do it.
Why is she yelling?
I don't know.
The only thing I would add, Your Honor, is that it has come to the attention of the One Heart that Mr. Egger has a pirated copy of Exploding Cats. And as that is potentially another charge here, I would respectfully request that the court get the maximum amount of bond.
Your Honor, this is the second time here today that I have been given information at the hearing that was not provided prior to. I really don't find this to necessarily be fair until I have had an opportunity to corroborate that information and speak with the prosecution. I think that again, that is way too high of a bail, and that this needs to be put to something a bit more reasonable.
Yeah. That be all? Okay. I'd like to say this is a Class C felony. You should take this very seriously. Jay, are you? Our furry friends are valuable hearts too. So I appreciate the extenuous circumstances of this information, and this court will take that seriously. The conditions of your bail will be absolute sobriety from your video games. However, the court imposes its right to increase that you must raise 20% of your bail. Your bail will be set at $4,000. Unfair! I feel like you need to go check on my cat. Where's the cats, Jay?
Shh. I want to see these exploding cats. Sounds like fun. We need to recess. I want to go out for recess.
No, Dad.
I'm going to go out for recess. Can we go out for recess?
Does your client not want to leave?
I think that he's just waiting for his pretrial date.
Your Honor, I have the next case. It is the One Heart versus El Protecto. Mr. E.P. has been charged with illegal restraint and containment and bribery. You didn't do that. This also is a Class C felony. And that maximum sentence is 40 years of no flying.
Excuse me. Philip, will you remove these food? There's no food in my courtroom.
You're right, there's no food here.
No food in my courtroom.
All right, EP.
This contraband should immediately be
No
put
cookies
evidence.
here. No cookies. Oh my
They're
goodness.
under your butt, EP. Lift it.
Uh-oh.
Cookies.
Okay, now where's the other one?
Gee, really?
Oh, EP. Oh,
Man,
we're going to rename
Green smoke, man.
Sorry.
Whoa, damn.
Sorry.
What else did you eat?
Am I in contempt?
You should be.
It was probably the cats. Let's continue, please.
Those are the charges, Your Honor, and the maximum penalties.
I didn't even hear that. I think that my ears curled up once that odor came out.
In your ears? You smelled it?
Mm-hmm.
If the prosecution would indulge the court to please repeat the charges.
Your Honor, yes, I will. Mr. EP has been charged with illegal restraint, containment, and bribery, the Class C felonies, with the maximum penalty of no flying.
He didn't
40 years.
No
I don't
way.
need your wings clipped, dude.
Do you need to approach? Clearly, this seems new evidence. Do you need to approach the bench, or are we good?
I think that, yes, I think it would be a good idea to approach.
Okay, let's approach, please.
You gotta stay here.
Come on.
Where are they
We're
going?
having a sidebar.
Is it over?
Sidebar. No, quiet.
I like her coat.
Okay, let's go on.
Yeah.
Nice coat.
What is this? part of the statute
No.
that I did not, I mean, this is.
Give me a
all
cookie.
weird That we're up against the
No.
That was that an
Behave
amendment?
yourself.
Was this the
Hey,
EPA
hey.
injunction?
No cookies in the courtroom.
Come
Come here, give me that cookie.
This person is strangling the dragon.
Quit choking the dragon. Here's a chocolate chip.
Just a moment. Hey, excuse me, bailiff, can you please calm these people down? We're trying to have a meeting here, and it does have some impact on my client.
You're fixing to get the max if you don't shut up.
Protect them, contain yourself.
And who said that wasn't an ill expense?
Put yourself in a container.
I agree.
So, can I just please have the statutory reference on what this, this special provision is, because he has.
That was the FAA violation?
It's one heart statute, number 777.241, sub A, sub B, sub 1, sub 2.
Very good, great.
Anyone change?
Continue.
Thank you.
You want me to put you in change?
Careful.
Keep doing that.
To the FAA, just for you.
Federal Awesome Association?
So they're gonna, they wanna take your wings. So you've got to pay attention.
They want to take his wings.
Don't let them take your wings.
Don't hate me for who I am.
Don't you know what they do with those little parrots? When they bring them in the cage, they rub them.
You sound like a
Calm
parrot.
down. You got to calm down, man.
Oh.
Okay, please? Can you do that?
Oh.
Are we ready to
Okay.
continue?
If you're gonna clip your rings, would you sit down?
Just don't let one again.
Oh.
Yes. At this time, on behalf of Mr. EP, we enter a plea of not guilty.
Your Honor, this is a very serious felony, felony C. And so for this class, we request a minimum of $4,000 cash bail. And because Mr. Protecto is a flight risk, he must remain on a tether.
I object! That was the worst pun this court has heard in years! Unacceptable!
This is a bail hearing. There are no objections. Please continue.
Damn it. Oh, sunk in a ditch.
My apologies, Your Honor. Because Mr. Protecto was a flight risk, he must remain on a tether for the entire time of his bail and absolute sobriety from.
You get to wear leather!
Feather.
Defense have any arguments?
I do, Your Honor. Just one moment, please. I'd like to consult with my client.
Absolutely.
Screw the tether.
Is he farting?
Oh, no!
Trust me, I'll know.
I'm agonizing. Okay, let's see. Cookies or tether? Cookies or tether? Strap me down, mama, and give me the cookies.
Your Honor, after having an opportunity to consult with my client,
Yeah.
Mr. Protecto has indicated that although the $4,000 cash bail is very high, we do understand that it is a Class C felony. However, other conditions are such that if he would be able to raise that type of cash bail, that, of course, I think would be more than enough to ensure that he would return to court for each of his court appearances. After all, when you think about it, $4,000 can buy a really lot of cookies. And he's advised me that he would prefer tethering before absolute sobriety from cookies, given that this particular allegation does not involve cookies per se. It seems to me punitive for him to have to maintain absolute sobriety from cookies. That seems a little unreasonable. Whereas, you know, if you're just looking at purely a flight risk because of his little wings, the tethering part of it we would understand. However, I could see that as a condition if it was a $4,000 recognizance bond. But to otherwise post that and have the tethering and the sobriety, absolute sobriety would be way too onerous and way beyond what is called for this particular offense.
What is he talking about?
So at this time, our recommendation to the court is that that the $4,000 remain as just a signature bond and as a condition allow the tethering. However, again, because the cookies do not have any bearing on the issues of this case.
Can I consult with my esteemed counsel, please, for a moment? Can I have a moment? Just a minute. Just a moment. Okay. Okay. So, chocolate chip is my preference. Chocolate chip.
We're talking about the video. Who cares?
I thought we were talking about cookies.
Well, that's gonna try and make sure that you can still have your cookies.
And specifically, I want chocolate chip.
We're not buying them for you. This is just.
What? What is this all about?
It's about whether you get to have any cookies.
Exactly, and I want chocolate chip.
Picky on you.
Peanut butter's okay, but oatmeal, blah, especially raisins.
Look what you did.
What did you
Alleging that
do?
you violated the law, and now you're getting picky about your cookies.
I have been flying around this planet for 4,000 years. Your upstart country starts about 200 years ago, and all of a sudden I can't fly
They
anymore?
don't have
That's
it.
crap.
They don't have it tethered that long.
Oh,
Okay, you just said strap me down. I want my cookies.
that's right, chocolate chip.
Fine. All I'm saying is I'm trying to save you some money here so you can buy your chocolate chip.
Oh,
Okay,
is that what we're doing?
that's what we're doing.
Proceed.
Okay, thank you. So, in conclusion, I would just reiterate that, again, the preference clearly is that Mr. Protecto would not object to the tethering condition. But again, since our case does not have any bearing on the cookie part of it, that, like I said, that just seems punitive in nature and is wholly irrelevant to this case, and therefore I do not understand where the prosecution is coming up with this other than just being vengeful.
If I may respond, Your Honor, we stand by the $4,000. This is a very serious crime. This is bribery, and bribery by the use of chocolate chip cookies. So we would definitely request that absolute sobriety from, and I would be willing to modify absolute sobriety from only chocolate chip cookies.
Oh,
We would be agreeable to.
you're killing me, lady.
Who is she? She's the prosecutor.
She's the persecutor.
Is that all?
Can I respond, please?
Absolutely.
Without having a clear factual basis before us, until we receive all the discovery in this case with the investigation and the police reports, I have to object to the narrative nature and just the type of summary fashion of the facts in which is basing their argument, they are making decisions for the court without any type of trial here. We do not have a conclusion. We have constitutional rights. Mr. Protecto has his right to a trial. And until some of these determinations are made by, well, his peers,
EP, here's a cookie I owe ya.
we really cannot make those type of judgment calls at this time. So, again, I will just reiterate that my original recommendation stands and ask that the court consider that.
I have no further argument.
Okay, I'm ready to rule on your bail in this case, Mr. El Protecto.
I'm ready. Hit me, Judge.
Now remember, it's in this court's interest because of the severity of this Class C felony to make sure that if we do offer you and award you bail, that we're here to protect the community as well as yourself. Given the humane practices that have been developed in tethering, I'm going to allow that. So the tethering will be ordered. In the condition of bail regarding absolute sobriety, I will go with the recommendation of prosecution for only chocolate chip cookies. And I would like to say, because I feel that he's provided a displayed addictive behaviors, that we order chocolate addiction treatment as well.
I can stop at any time. I just need some
The
cookies.
bill is ordered at $4,000 with the.
Oh, you're killing me. Oh,
How you know?
justice is dead.
I'll file another bail motion as soon as we get to the next day, okay?
File in a chocolate cake. Great idea.
Well, not that kind of file,
Ah,
but I'll do my best.
okay.
Okay, I'm sorry, EP.
You did your best.
You should have paid me up front.
What? Those drinks meant nothing to you? I thought we had something going, you and me.
EP, you're gonna get us in a lot of trouble.
I mean,
EP.
EP,
What are you
I'm
doing?
over here, lady.
you know, EP, you might be right about that chocolate. It seems to have gone to your head.
No.
All right.
EP, I'll tell you a secret. Chocolate comes in forms other than cookies.
I think we have a chocolate dealer in the house.
Bars. With my M&M's. Reese's peanut butter cups.
Being chocolate is
Okay,
addicting,
okay,
but you shouldn't
okay.
fuck.
Okay, did you hear me? Did you hear me?
Excuse me, please stop enabling the claim. It's ordered to do chocolate addiction treatment, and you're not helping, you're enabling by providing all these ideas. I don't want to do this in my courtroom. Please, next case.
Can I go to my cell now?
Yes, you can.
Don't step on my toes.
Oh.
Dance.
Does John have to dance with it now or no?
The One Heart now calls One Heart versus Margaret Koval.
That we do.
No, why am I here? Are you gonna tell me everything?
I'd like to add another charge. She's been totally disruptive during all these court hearings and procedures.
Objection!
What are they talking
The
about?
bailiff is not here to discuss things with the prosecution. The prosecution already has their case. The bailiff has something to say, can discuss it with the court.
As we determine this is a bail hearing, not a court, there are no objections. Can we please continue?
Yes, there are.
Are you here?
Thank you, Your Honor.
That's good.
Ms. Koval
here.
has been charged with a Class F felony for fraud.
I got an F.
Severe CRS.
What's that?
Can't remember shit. I can't.
The the maximum penalties for these charges are a potential lifetime residency at the Mendota Mental Health Institute. What?
Excuse me, prosecution, are those the bail conditions or are you saying maximum penalty?
These are the maximum penalties.
I'm not going to Mendota.
With the condition that you would have to sit in a room with someone that was knitting something that was not there.
What is she talking about? I can't remember shit and you're telling me shit.
On behalf of Ms. Margaret here, we enter a plea of not guilty and not guilty by reason of mental disease or defect.
I can't remember the last, why am I?
That's why I put in that plea, not guilty by reason of mental disease or
I'm not
defect.
crazy, I just don't remember shit.
I understand, that's what
You said I was crazy.
I did not.
Mental defect, what does that mean?
Disease or defect, that there's something wrong because you can't remember shit.
Why do you bring your eyes way down here?
Because I'm reading data down here.
Oh. So why am I here? Shit. Oh,
Yeah, it's a technical term, CRS.
all right.
It's in, yeah, it's in the DSM. But
Where, show me that. Look that up, show me that.
I don't have it on me right now.
Do you have it on that little machine?
I can probably look it up.
Jay has something like that.
Does your client now understand the charges?
No.
She's having a hard time, Madam, and that's the reason why I had to put in the special plea. So,
I am special.
please, please bear with us. She's difficult. You know, when you can't remember anything, it happens.
Well, you couldn't remember shit, so I just figured it happened. Well, yeah, I should, don't you?
What?
CRS. Yeah, right.
Your client is shit right now, did she?
What?
No, that still remains for me.
No, I did not.
EP lingers.
Your Honor, the One Heart would ask for a minimum of $2,000 bail with the condition that Ms. Paul submit the competency exam, and that competency exam should be with the illustrious Fraser Crane, the radio psychiatrist.
Oh, I could talk to Fred, what?
What?
God, gee, you was right. Why am I here?
Your Honor, actually, at this juncture, I think under the statutes, like, the psychological evaluation would have to be done, not necessarily a competency examination, but a psychological. We have to get to the root of the problem as to why she cannot remember caca. However, I think $2,000 might be a little
Where am I gonna
much.
get $2,000?
And
But I don't even know why.
exactly. So she, if she doesn't know why she has to pay the money, it's going to be difficult to raise the money.
I got $50.
I think that instead it would be a rather better idea for her just to have a personal recognizance bond pending in a full psychological makeup here, and we do a full battery of tests.
I don't
on
wear
her.
makeup, Wendy.
Do I understand this correct from the defense? You want to add additional evaluation?
Yeah, I think we should have a full
Okay.
psychological.
Make sure the prosecutor-
Wait, what am I
aware of
taking
that.
a test?
Yeah, we're gonna do the MMPI.
Take her to the funny farm, funny farm.
Jay, where are you? Your Honor, no, as conditions of bail, I would not request to have those additional amounts made unless, additional tests made, unless the defense was going to pay with the One Heart for those additional exams. All we need is a mental competency in order to determine whether that Ms. Popal is competent to stand trial on her Class G felony.
I thought
And
it
based
was,
on that Class G felony.
F.
Oh, is it class F, wasn't it?
Correct.
Oh, thank you, sir. It's a Class F.
I'll take a G though.
And so, based upon her class felonies, encourage the court to please set a bond of $2,000.
The prosecution is asking for the competency, so they're gonna have to foot the bill for the competency. That is questioning now whether she will be able to proceed to trial. I have put in a special plea for not guilty by reason of mental disease or defect. That goes to at the time the crime was committed. So at the time the crime was committed, I need her mental status for that time to be tested. That needs a separate psychological. And under the statute, we each have to choose our own psychologist for it. We can start with the competency, but then move to the NGI is a different phase and a different question altogether. So if we want to start with competency, that's fine, but then we have to go to the next step. Real life.
Your Honor, I think we're getting well beyond the bounds of the bail hearing at this point.
I don't get it. I still have to enter the
I have entered what I believe is a reasonable request, but in the one heart that we have $2,000 bond with the condition that we submit to a mental competency exam. That's considering it's a class F, I keep moving all around, class F felony. I think that these bail conditions are very reasonable.
Well, I'm still questioning the $2,000. My client, clearly, if she has to pay these additional costs, she is not in any position, since she's not working, to be able to post that type of a bail. And the competency, like I said, obviously that's something that this prosecution would have to pay. Like I said, with this at the arraignment, this is the time for me to enter the special plea, and that's why I've done so. Nothing further.
Okay, I'm ready to make my ruling on the
Good question.
This isn't school. Please talk to your client. I'm going to make my ruling. It's clear that a competency test will be performed by the renowned Dr. Fraser Crane. I agree. I feel it's the top of his field. I will also go further to say that I feel that the individual's mental condition has severely depleted, just sitting in the courtroom here today, that the NGI would be beneficial and the state will put up that cost.
Really?
Bail will be set at $2,000. I hope you remember where that shit is.
What shit? The money. Okay. You have a wallet right there? No. Well, then it's going to be tough. Right. Get out.
Where?
Yeah.
Who's going to jail?
You.
Well, what the hell?
I know. Ain't that a bitch?
I thought you sent me to come here to play. And they want to put me in jail? Hey!
You remembered something at one time, because boy, you fooled somebody. Charged for fraud.
For what?
I'm on vacation, leave out.
You have to remember shit.
What the hell?
We'll find out when we get that.
Say help.
When we get
Can you
the.
take me away from this? I don't know what's going on. Help the handicap.
Yes.
Push your head, not your feet.
Your Honor, our next case, One Heart versus Patricia Clayson.
You the star chamber over there.
Court would like to add, given the severity of this Class A felony,
Oh, she didn't even say what felony was.
to have, I'm obviously aware of what's going on here, ma'am. Could you please keep it down? I would like the enforcer to move up just slightly to keep an additional eye on this individual. Thank you. Bailiff, you ready? Please continue.
Thank you, Your Honor. Ms. Clayson has been charged with 2 Class A felonies, inciting to riot and attempt to overthrow evil. Maximum penalties for each of these charges is life with no humor.
On behalf of my client, Ms. Clayson, we enter a plea of not guilty to both counts at this time.
As to bail, Your Honor, there was a disagreement in my office as to whether we should ask for bail at all and only ask for remand. We have concluded that we will ask for bail, but with a number of very specific conditions. The bail amount would be $7,000.
Wow.
And the reason for this is that Ms. Clayson has been found to be the ringleader and instigator of a number of these other charges and other individuals that you've seen in your courtroom today. So we are asking that in addition to the $7,000 bail, we have electronic monitoring, random screens,
Keep it down.
and no talking until 50% of the money is raised.
What was the second one?
Talking?
No talking.
I always heard that. Well, you were talking when she was talking.
Defense, you ready, or do you need to confer with your client?
One moment, please.
What are they talking about?
No. I don't know.
Don't tell me you have CRS too.
No, 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 no. I don't understand. I haven't done anything wrong. I've done good things.
Oh, okay, so,
Thousands of people went through workshops that helped their hearts heal. I mean, if I'm inciting a riot, it's a riot for love. I'm that bad.
I guess you need to ask the prosecution that, but they say that that's against the law. Because people rather linger in their shit.
I knew she was gonna say that.
And it's easier to pout and be in self-pity and think about ways to hurt other people than it is to be happy. So I should, well, either that or don't get caught.
La la la. Are we singing? I wasn't singing. La la la. What do we do?
Well, right now we're gonna enter plea not guilty,
Okay,
okay?
Yeah.
We're gonna get out of this.
okay,
And so you can continue on.
okay.
And then we'll go to take a picture and we'll change everything.
We'll change the law.
All right. All right. This time we enter a plea of not guilty on behalf of this place. And I'm gonna say right now to the court that this here is probably the most ridiculous law I've ever seen in my life. You know, when you're trying to do something that's right, it's positive for the community. This is just immoral. This is unbelievable. I can tell you right now that $7,000 is pathetic. It's way too. It's just way out of line. And to say that this woman cannot talk as a condition until 50% of that is raised.
That's against the Constitution.
How can she possibly then raise it?
Freedom of speech.
I mean, she has a First Amendment right, freedom of speech. Her constitutional rights are being infringed upon, and clearly there is no possible way that that can happen. It is inherently contradictory to even trying to get to that point if she cannot speak. So I understand that the inciting riot or attempt to overthrow evil all originated from the talking. However, if at this point in time, she is supposed to remedy this and the court wants her to change her sinful ways, the point is that she can't come up with that amount of money without the ability to talk. So maybe on the back end, but not the front end. She needs to speak to get out. Now the random screens, of course, Now, that I'm assuming is on whether or not she has been exercising her speaking rights. And I guess we'd have to discuss the logistics on that type of thing. With the electronic monitoring, though, again, I think that that would be reasonable in lieu of the $7,000 if that were to be a signature bond.
Your Honor, let me read from the warrant for this, this offender. Defiant, unwilling to submit to fear, drama, and lack. Be aware that contact with subject may shift your heart to compassion and peace, causing you to want to unleash her on the world. She is very definitely a ringleader and an instigator, and it is through her speech as part of her raising of the bail, because there is some type of control if she would type in or handwrite something and seek to get donations for her bail in that manner, and someone else then communicates it out into the world. Once it's been reviewed by the bailiff to ensure that it's not instigating any of these bad behaviors, the prosecution would be willing to amend their bail request. As to the rest of the conditions, we stand for what we've asked.
Just so I understand, so the prosecution is stating that that it's amending the request to her ability to express herself, well, albeit reviewed, through the written word rather than verbally.
That is correct, Your Honor.
Okay, one moment, please. Is that okay? If the court would still consider the 7,000 in a, or at least to divide it, having a portion of it to be personal recognizance and a portion of it to be additional amounts raised by her, then with the written word, we would not object to that particular condition.
Nothing further, Your Honor.
Okay, court's ready to make its determination about your jail bail hearing here. This is serious, Mr. Cosby. This is serious. Being a ringleader and a focal point for all this happiness and love that's going around, we need to crack down on this. It's contagious. It's a disease. EPA is concerned. You know, and if we don't constrain you now, this could definitely get out of hand. You could be touching too many lives. This love could just keep going and going.
Yeah.
The court's very concerned about you being a ringleader, and sometimes we have to try to get the ones who are causing all the problems. It's very serious, very serious.
What a freedom of speech.
Therefore, the court does recognize you to be the ringleader of this crazy band of love and warmth and everything going on. Electronic monitoring, that clearly there's no argument there that we need to do this. We need to make sure we know where you are, what you're doing, spreading all this joy and happiness. It's getting out of control. The random screens, I will enforce. These screens do confirm new testing, and we're going to enforce this as part of your bail because this measures the amount of love and happiness that is within you at the time. Therefore, if we see high levels of this, therefore, it is going to be a violation of your bail. And we need to keep you silent until you raise 50%. I will be invoking the maximum of the $7,000 requested bail. You may put out the written word, you may use computers, you can touch everyone and see if you can beat this with your, not just your voice, but also your heart. Bail conditions have been set, $7,000.
Who's gonna be the ringleader now?
Oh, I'm sorry.
I'll file it.
You fix this, Wendy, you fix this.
Can I ask the court one consideration, please? That her mandatory no speech policy for the world at large is accepted for her attorney. Obviously, we need to speak.
And obviously, I think it's clear you've spoken a lot tonight for everybody, so that seems, and how does the prosecution feel about this?
We will not stand between a client and their attorney, Your Honor.
And the court so agrees.
Thank you. All right, I'll go and tell everybody.
Okay.
All hail to the ringleader.
In the court.
Oh, the
Yeah,
bailiff
they'll have
plan.
to say all rise.
All rise.
All rise. Ugh. Military bailiff, take us out.
I'm the MP.
Be an MP then, take us out.
Kim was great.
Really good.